I have a song to sing, it is a song of political corruption, of judicial corruption, probably bribery, of banking frauds, money laundering to the tune of $10 billion, and perjury in the UK Court of Appeal and the Birmingham Mercantile Court. The banks in question are Deutsche Bank, HSBC, UBS, RBS, Barclays, Citigroup and JP Morgan. The corrupt officials are the Attorney General, Jeremy Wright MP, the Lord Chief Justice, Baron Thomas, Paul Kernaghan, head of the Judicial Appointments and Conduct Ombudsman, Lord Charles Haddon-Cave of the Birmingham Mercantile Court, and Simon Brown, who's now retired, of the Birmingham Mercantile Court. Now, in a New York lawsuit under Valerie E. Caproni, Deutsche Bank, HSBC, UBS and Scotiabank were accused of systematically suppressing the prices of precious metals for the past 17 years with the aim of defrauding their own clients. They applied to have that lawsuit struck out as a nuisance action. When Judge Caproni refused their application, Deutsche Bank immediately settled. To date, they've settled for $98 million, and as part of their settlement, they've disclosed materials that have incriminated co-defendants, so this settlement functions as a confession. Now, in my lawsuit in Birmingham, B40BM021, I'd made the same allegations. The key evidence was that correspondence Deutsche Bank had sent to me contradicted an article Reuters had published in which Deutsche Bank were claiming to be auditing their gold trade for market manipulation. In their defense, they'd submitted a bare denial verbatim. All defendants built their defense upon that of Deutsche Bank. Deutsche Bank's bare denial is meant to be outlawed in almost all jurisdictions. Bare denial should ordinarily result in summary judgment against defendants. You're meant to substantiate any defense with hard evidence in civil action in almost every court of law throughout the world. Deutsche Bank would not even admit or deny trading with me. I said that I'd bought and sold bullion from them. They never accused me of fraud, and they never admitted that the amounts I said I traded were accurate. No co-defendant showed the slightest bit of interest whether or not my allegations were fraudulent, which shows that all defendants conspired to produce a completely deficient defense that should ordinarily have been rejected. They applied for an oral hearing against me. Simon Brown QC sat that hearing. He's the judge. He said that he'd read everything. In the middle of the hearing, he said that my references to market regulator reports that showed that defendants had lied to the regulators during the Forex and LIBOR investigations, discrediting defendants, he said that was vexatious. In fact, he said everything was vexatious. I demanded that defendants turn up for court because they'd submitted no evidence, and I wanted to cross-examine them. He said cross-examination was vexatious, that my demand that they attend their own oral hearing that they'd applied for, he said that was vexatious. He used that as justification for a restraining order against me. Now, in the verdict, he said the key evidence that showed that Deutsche Bank's audits were fake, he said that was missing from the evidence bundle. Now, in UK law, since the defendants were represented by lawyers, and I was not under UK law, it's the defendant's job to file the evidence bundle. So if there's any evidence missing, then it's the defendant's fault. Instead of holding an adjournment at the start of the hearing, he's waited until the verdict to tell me that the evidence is missing. In the restraining order, which HSBC applied for, the date of application predates the date that all defendants were served with the lawsuit. The judge in that restraining order claimed that the restraining order emerged of his own volition, which is totally contrary to the application name and the date stamp. HSBC now incriminated in their New York lawsuit as being cartel conspirators to suppress prices of metals against their own clients' interests, to suck out the wealth of their own clients and consolidate it in their own pockets, clearly filed a restraining order against me, not just to hide the fact that they'd committed a fraud, but that there was ongoing frauds. So clearly Simon Brown QC not only conspired to pervert the course of justice, but conspired to commit an ongoing fraud. I shall show in parts 2 and 3 that the Court of Appeal and the Judicial Complaints Office were totally negligent and obstructive in handling 20 allegations of misconduct against Simon Brown QC. If there's any doubt in your mind that Simon Brown QC is a bent judge, then consider that I sent a letter to the Lord Chief Justice that showed that my allegations that Deutsche Bank had potentially committed money laundering was entirely consistent with the FCA and BaFin's findings against Deutsche Bank for money laundering. My accusations preceded the findings and conclusions of the FCA and BaFin by at least 6 months, probably a year. Judge Simon Brown QC, within 2 weeks of the Lord Chief Justice receiving my letter, retired 10 years early, without explanation. So the chances are the Lord Chief Justice had demanded he'd resign, but instead of my restraining order then being annulled or reviewed, the corrupt judges in the Court of Appeal effectively blocked further legal action. And I shall show that the Lord Chief Justice has allowed Lord Ian Burnett to help HSBC, UBS and Deutsche Bank commit ongoing frauds that have yielded ongoing damage against British investors contrary to the public interest and conspired to pervert the course of justice at every stage.
Hating, hating, misery me like a deity. His pains were already sighed no more, for he lived in the love of a lady. Hating,